Good afternoon and welcome to the Supreme Court of the United Kingdom. We are hearing an appeal in the case of Triple Point Technology Incorporated and PTT Public Company Limited, which raises matters of contractual interpretation. And we are currently hearing the submissions on behalf of the respondent by Mr. Andrew Stafford, QC. Mr. Stafford.
Thank you, my lord. Before the short adjournment, we heard Mr. Howells say that the words appearing in the fourth sentence of Article 12.3, fraud, negligence, gross negligence, or willful misconduct, were all descriptive of the quality of a breach of contract. And indeed, I was pressed by my Lord Legate about to a similar end with the presence in many contracts of gross negligence, willful misconduct, and fraud. My opening submission in this afternoon session is to make this particular point. If Mr. Howells is right, and those four concepts are all descriptors of contractual non-performance, breach of contract, then that interpretation has the consequence of rendering completely useless and superfluous the phrase gross negligence. And that is because every case of breach of contract which constitutes gross negligence must also constitute negligence. Every case of gross negligence is also a case of negligence, so gross negligence has to be given no meaning whatsoever. And we say that that adds to the submission that I was making this morning, that the panorama at which sentence 4 was looking was not limited, as in the case of sentences 2 and 3, to under the contract, arising out of the contract, and that the omission of any similar qualifications shows that this sentence has a broader object in mind. Now, I also, before the short adjournment, said I was going to take you to a couple of authorities. I'm not using them with a view to establishing any proposition of law. I want to use them to amplify, if I may, the proposition that there could be negligent conduct outside the scope of the contract, which could be a meaningful subject of the term negligence. So if I could take you to the first of those cases, it starts at page 1185 and is Holt against Payne Skillington. And just to introduce this, it's a case which concerned allegations of negligence against surveyors. And those surveyors have been engaged to find properties to buy for use as holiday lets. One of the allegations, which I should add did not succeed, was that the surveyors had gone beyond their engagement and had provided negligent advice about the planning position. I want to take you to a couple of passages where the argument which ultimately failed to do because of the course of the trial and the pleading was articulated and then commented upon by the Court of Appeal. At page 1206, could I ask you to find the paragraph that starts between letters C and D? And the opening words are, Mr. Lewison submitted that. If I may, I'll read that to you. Mr. Lewison submitted that if the assumption of responsibility and concomitant reliance which founded the duty of care in tort was referable to a wider set of factual circumstances than those which gave rise to a concurrent contract between the same parties, there was no reason in principle why the duty of care could not impose wider obligations than those arising under the contract. And that essentially is what I'm saying is the subject matter, potential subject matter, of the word negligence. Commenting on that, page 1207, Lord Justice Hurst, a sentence beginning between letters D and E, starts this sentence with the words, a consideration of individual facts. Do you have that, my lord? And the sentence continues, a consideration of the individual facts and circumstances of each case will determine whether any duty of care in tort, which the general law may impose, is of wider scope than any contract to which the same parties may agree at some stage during the same course of dealing. It's important to emphasize that the duty of care in tort is, in appropriate circumstances, imposed by the general law, whereas the contractual obligations result from the common intention of the parties. In our opinion, there is no reason in principle why a Headley-Byrne type duty of care cannot arise in an overall set of circumstances where, by reference to certain limited aspects of those circumstances, the parties enter into a contractual relationship involving more limited obligations than those imposed by the duty of care in tort. So that's my way of trying to populate what I'm describing. If I may then take you to a subsequent decision of the Court of Appeal, which is Robinson and Jones, and that starts at page 1348. And the leading judgment in that case was given, as in this case, by Lord Justice Jackson, as he then was. It concerned a defective building. If I could take you to page 1365 and paragraph 77, the last sentence, Lord Justice Jackson records from his analysis of Lord Gough's speech in Henderson and Merritt, Lord Gough is not saying that every contractual obligation to do something carries with it a parallel tortious duty to do the same. He's simply saying that the existence of a contract does not prevent a tortious duty from arising. At paragraph 80, which appears on page 1366, the essential points which Lord Gough is making in his detailed discussion in Henderson's case may be distilled. One, when A assumes responsibility to B in the Headley-Byrne sense, A comes under a tortious duty to B, which may extend to protecting B against economic loss. Two, the existence of a contract between A and B does not prevent such a duty from arising. Three, in contracts of a professional retainer, there's commonly an assumption of responsibility which generates a duty of care to protect the client against loss. Paragraph 83 on the same page. In the present case, I see nothing to suggest that the defendant assumed responsibility to the claimant in the Headley-Byrne sense. The parties entered into a normal contract whereby the defendant would complete the construction of a house for the claimant to an agreed specification, and the claimant would pay the purchase price. The defendant's warranties of quality were set out. The claimant's remedies in the event of breach of warranty were also set out. The parties were not in a professional relationship whereby, for example, the claimant was paying the defendant to give advice or to prepare reports or plans upon which the claimant would act. And then I take you, please, over the page to 1367, paragraph 87. Let me now draw the threads together. The rights and remedies of the parties to this case were set out in a written contract, the terms of which were clear and simple. The contract provided the claimant with extensive but not total protection against the defects. The contract represents a perfectly sensible allocation of risk between them. At the time of contracting, both parties were represented by solicitors and they must have known where they stood. So those two cases, as I say, no proposition of law, simply reinforcing our points about allocation of risk and how, when referring to negligence, what the parties here were accepting was the known unknown. It is known that there are these events out there. Which side of the total liability cap do they fall? Answer: they don't get the benefit of the total liability cap. So those are essentially the submissions on my part of the case. Before I beg your pardon.
I've got two questions for you, Mr. Stafford. The first is, let us accept that negligence may extend more widely to assumption of responsibility outside the contract, at least in English law.
Yes.
It's not enough for your case to show that, is it? You have to say that the word negligence here excludes negligence in the performance of a contractual obligation.
Oh, quite so, and we do.
And so you have to read that. You have to read that effectively into the law, don't you?
We're at the risk of being repetitious. It's paragraph, I think, 262 of Mrs. Justice Jeffords' judgment, where effectively she said that she interpreted the contract to mean that the parties did not intend to throw the baby out with the bathwater, that the principal obligation of reasonable skill and care. She did not interpret negligence in the meaning given to it in the fourth sentence here to have the effect of excluding from the total liability cap what she called the principal obligation. And I've just called it throwing the baby out with the bathwater. So we accept your proposition. We do have to do that, but we say that we meet that because it would make, we say, no sense to construe it in any other way. My Lord, that was your first question.
Yes, no, well, my second proposition is that there is a long line of authority, as you obviously know, which Canada steamship is no doubt the best known case, that says that if you want to exclude or limit liability for negligence, clear words are needed. And indeed, Lord Wilberforce endorsed that in photo production, although he didn't actually apply it. Now, we all know that in a commercial contract like this, we don't strain too hard, as it were, to read down what is, on an ordinary reading, an exclusion of liability for negligence or limitation. But there comes a point, doesn't there, where we don't try too hard, as it were, to bend over backwards in favour of the defendant. And if he hasn't clearly made it clear that negligence is excluded, at least of the relevant kind, then you lose. You accept that?
I accept that if you don't subscribe to my submissions and you take the view that that this does not have the clear meaning which we say it does, then it follows as night follows day that we lose. But it's in our respectful submission, it is clear. And I revert, if I may, to my baby in bathwater. It's a very, very stark conclusion in our submission. And when one thinks about the route that Mr. Howells invites you to take in order to secure the conclusion that this is not clear in the defendant's favour, we say it is. It involves reading sentence 4 so as to give no meaning to the word gross negligence, ignoring the fact that the panorama covered by sentence 4 is different from the panorama covered by sentences 2 and 3. And we say that this court, like every other court, doesn't have to work too hard, but it does actually have to work. And we say that the invitation Mr. Howells is extending is to take a superficial view of the word negligence and stop your work there. And we say, no, not so fast. If you look at this clause and try to give it meaning, taking into account that the object of the total liability cap is to provide a meaningful cap, then it becomes necessary to do that work. And when one does that work and realizes that one is throwing the baby out with the bathwater, we say it's not hard work. We say it's clear, and it's clear in the defendant's favor.
Thank you very much.
I wanted to conclude my submission by just trying to summarize for you what is involved in subscribing to the case advanced on Article 12 by Mr. Howells. Excuse me. First of all, he is asking you to copy and paste the exception which appears at the beginning of sentence 3 into sentence 2. Secondly, he's inviting you to adopt an interpretation of negligence which would render the expression gross negligence entirely superfluous. Thirdly, he invites you to ignore the absence of the telling phrase under the contract, which is present in sentences 2 and sentence 3, but not sentence 4. Fourth, he invites you to adopt an interpretation of negligence, which would drain the total liability cap of almost all practical benefit. And fifth, he invites you to treat Article 13 as a first-party indemnity, so as to render the entirety of Article 12.3 almost entirely pointless. We say that is an invitation made to you by Mr. Howells, which you should resist. My Lord, those are my submissions on Article 12.3. Unless I can assist you further, I'll make way for Mr. Darling.
Any of my colleagues wanting to ask you any further questions? Thank you very much, Mr. Stafford. Mr. Darling. Yes.
May it please, my lady, my lords, may I first of all apologise for the fact that I will be described on the video link as Andrew Stafford. It seemed to us that the logistics involved in changing that were not justified in view of the fact that I hope that the difference between us will be sufficiently clear without the label.
Well, the bench can live with that complication.
I'm very grateful to my Lord. My Lord, what I propose to do is to introduce the submissions that I make in relation to Article 5.3, as I shall call it, with a few preliminary remarks. I shall then go to deal with the principles of construction briefly. I shall then look at the principle of accrued rights surviving termination. I shall then go substantively to the wording of clause I beg its pardon, Article 5.3, and I will then conclude with some observations about standard forms generally, the decision in Glanstock to the extent relevant, and the so-called chaos that a decision of the Court of Appeal, the decision of this court in my favour would allegedly cause. Starting with my introduction, may I just make 8 points. The first is that we are dealing with essentially a question of construction of a contract. And the fundamental principle is that contracts have to be construed according to their content and according to the rules which were carefully set out by the judge as embodied by the decision of this court in Wood and Capita. Secondly, there's no general principle of construction for particular types of contract in general, save for the general principle set out in Wood and Capita. Thirdly, and this is going to be an important limb of my submissions, it is established and clear case law that whilst accrued rights following termination, accrued rights survive termination, those are rights that have been unconditionally acquired. And when we look at the authorities and look at that in the context of Article 5.3, it will be our case that such rights have not been acquired and certainly have not been unconditionally acquired. Fourthly, once the court accepts the principle, as I submit it should, that each contract should be construed sui generis and that accrued rights must be unconditionally acquired, it becomes clear that the wording of Article 5.3 is the key question that arises, and the question for the court is whether the rights thereunder were unconditionally acquired before acceptance or not. Fifthly, it is clear we submit that the wording up to the words, and I use inverted commas, up to the date PTT accepts such work, demonstrates clearly that there has to be acceptance of the work before the entitlement to liquidated damages accrues, crystallizes, whatever label one attaches. Sixthly, the liquidated damages clause should be construed as only applying or being conditional on, whichever label one seeks to use, on acceptance of the work. Until there has been acceptance, the Article 5.3 does not come into play. Seventhly, we say that PTT's approach is, and I intend no discourtesy to my learned friend, polluted by over-analysis and contrived constructions, contrived consequences, which in our submission do not ultimately assist the court in the task. And finally, we say that that all of these conclusions lead together to a clear consequence that Article 5.3 only became an acquired right at the stage of acceptance. Can I then move to my second topic, the principles of construction? No one disputes that Wood and Capita is the appropriate course. It was neatly summarised for these purposes by the judge at paragraph 56 for the court's note, page 147 of the electronic bundle. There was one matter one matter in Wood that I want to refer to a little bit later as to the relevance of other contracts, which the judge didn't refer to, but in general terms, there is no dispute between the parties as to the exercise that we are required to conduct and which this court is required to conduct. This is an odd contract. In my note, I planned to draw the court's attention to Sir Rupert Jackson's observation at, for the court's note, page 158 of the bundle, paragraph 127, Roman numeral 3 of the bundle of the judgment, that the draftsmen of this contract were not trying to make life easy for the reader. I've written against that when my learned friend Mr. Howells fairly and helpfully described this as a messy contract pulled together from a number of different sources. Indeed, one of the ways when one is looking at the nature of this contract, the termination clause itself has two different forms of termination remedy, which look to an informed reader as if they've been pulled out from two different standard forms for the same purpose. As a consequence of that, we respectfully caution against over-analysis and what, in Nade's case, again to my learned friend, we say verges on sophistry in some of the factors put forward. And there's an awful lot of discussion as to whether or not a particular construction produces a fair result or a reasonable result or a commercially sensible construction. But those are very difficult factors to take account of and to give weight in a complex and poorly drafted contract first, but then one which contains complex commercial provisions and limitations. Mr. Stafford and Mr. Howells addressed this court at great length this morning on the way those limitations work. And it is clear that this is a contract where the parties, by their words, engage this complicated set of risk allocation. And in my submission, looking at the consequence of that is not ultimately going to assist in the process. One of the things that pervades my learned friend's case, and which I know, bearing in mind the interest that this case has generated, whether justifiably or not is another question, is whether there are some sort of general principles of the construction of contracts in different commercial areas. Construction on the one hand, IT and similar contracts on the other, perhaps involving outsourcing, or shipping contracts. We say that what is clear, and what is the correct position, is that the court construes the contracts according to their terms and their context. That, of course, may involve consideration of the context of the area of commerce with which it's dealing, but that in general terms, what the court is concerned with is the contract in each case. And if I can just pause a second there. If one looks, Mr. Howells has produced, and I will address briefly some features of construction contracts, engineering contracts, the JCT, the NEC. There is a version he's produced that was not in existence very long, but there are all of these contracts in that area of commerce. They're all different, but taking each of them individually and comparing them with this software contract entered into in these terms between these parties in our submission does not help at all. Indeed, we're not clear what interplay the appellant says there is between software contracts and, for example, construction contracts. In paragraphs 5 and 8 of their case, bundle 26-27, they state that the Court of Appeal shouldn't have applied the interpretation of a clause in a construction contract to a clause in a software-based system, emphasising the fact that each of those areas of commerce is different, recognising that each contract, whether in a different area or not, has its own code, which will be responsive to different commercial circumstances. Then they call for consistency in the interpretation of liquidated damages clauses across the spectra. Now, in our submission, what you have to do is to look at the precise terms of each individual contract. Of course, as my Lord Hodge said in Wood at which I would ask the court to look at if it'd be kind enough, page 1488 of the bundle, where Lord Hodge refers to the reference to other contracts, where he refers to, apologise for the cursor. Yes, in paragraph 13, just below D, Lord Hodge says, there may often therefore be provisions in a detailed professionally drawn contract which lack clarity, and the lawyer or judge in interpreting such provisions may be particularly helped by considering the factual matrix and the purposes of similar provisions in contracts of the same type. So, of course, it's a useful tool to the construction, but we say that, which may be one of the reasons why Sir Rupert did such an exhaustive review of the authorities on this area, though there are other reasons for that that I will explain when we come to look at the authorities. We also recognise that each form of contract has each standard set of standard forms, and each area of contracts have the same concepts that they use, and they may use them differently according to different forms. But for example, and when I come to this, I'll spend a little bit more time on it. There is a very complicated set of certification provisions in many engineering and building contracts that actually, when you look at them, are a critical part of deciding where under those contracts what stage under those contracts liquidated damages do or do not accrue. But again, they are looking at specific techniques in specific contracts being used for particular purposes. Now, it appears to be suggested that there is some sort of special code or some special rules of construction for liquidated damages. We respectfully disagree with that suggestion. The liquidated damages clauses is the label used to describe clauses which, on their proper construction, cause the damage flowing from a particular breach of contract to be liquidated rather than unliquidated. Normally, liquidated damages are found, but again, it depends upon the construction of the contract, to be an exhaustive remedy, although very often what an exhaustive remedy for what is a matter of controversy in each individual case. Taking an illustration, there's a case in construction law from the 80s called Temlock and Errol, where the Court of Appeal held that under the JCT standard form, liquidated damages were an exhaustive remedy for delay. In that case, I'll be referring to by way of illustration, damages were there specified in the sum of £0.0, and I'll come to the significance of those sorts of provisions in a moment. But there have been many subsequent cases, several subsequent cases perhaps, which have asked the question as to what is the extent of the exhaustive remedy and does it bar or not bar claims for other breaches of contract. Whether it achieves that objective of barring other claims or whether it achieves that result of barring other claims is a matter of construction in each individual case. At that point, I wanted to address, if I could, a commercial feature of the liquidated damages provision. It's said on a number of occasions in this case that the employer suffers a detriment if the liquidated damages are no longer to be claimable, and the contractor suffers or obtains a benefit. We respectfully disagree with that and suggest that that adopts an erroneous approach to the question. It's wrong, we submit, to work out which party in a particular contract liquidated damages benefit, or who it disadvantages on the numbers in that particular contract, and then decide that as an aid to contractual construction. In this context, the liquidated damages can range between effectively a total exclusion of liability. The £0.0 in Temlock and Errol is a perfect example of that, where they operate very much for the contractor's benefit. They provide a contractor with a total in that case, and if it's £1 per day specified, a very small liability. At the other end of the spectrum, the clause may be so large that it just manages to sneak under the penalty rule, whether that was Dunlop or Cavendish. That is not a question of construction. The question is, what is the amount of liquidated damages and to what do they apply? It is not a question of a consequence that you can then say a particular unfair consequence has to be avoided. Of course, if the damages are very low or nil or very high, one might be able to take a view. But if they are in the middle, it's impossible to say which party benefits from them. It's a question of the actual numbers in a particular case, which the court, in my submission, cannot sensibly take account of in the exercise of construction. Of course, it's right that...
Mr. Darling, I'm not
yes,
sure if the appellants are arguing it's a matter of numbers in the case. I think the simple point that's being made is that if there are liquidated damages which have been agreed, then you don't have to go to the bother of ascertaining what are the general damages to which you're entitled. As I understand it, that is the point they're making.
But if, my lord, if I use my pounds nil example, if the damages were pounds nil, the employer would be delighted to go to the liquidated damages were pounds nil, and the employer would be delighted to go to the trouble of proving its loss, because it would be entitled to claim money that it wouldn't otherwise be entitled to. My lord is right, with respect, that one of the benefits for both sides of a liquidated damages clause is that it provides a sum that is paid, whether by limit or otherwise, without proof of loss. And of course, my lord is right about that. But whether that is where that benefit fits in the commercial considerations depends very much upon whether it's an amount. If the employer had if there was a very low figure, and let's say a pound a month, then the benefit to the employer of that having been pre-agreed and avoiding any proof of loss would in fact be of no benefit at all. So that's why in my submission I say it's amount. Though I recognise that when one is looking at liquidated damages in these circumstances, they are not, that there are factors depending upon the particular contract which may be advantageous to one party or the other. And if the parties had in fact chosen a figure that truly represented a genuine joint pre-estimate of loss, then that point would be a very good one against me. But of course, the authorities on penalties make it clear that penalties, that there's no such thing as a reverse penalty. And the fact that a clause is liquidated damages is in no sense, can't be regarded as a express agreement that was in fact the actual loss. It is in fact a replacement for the actual loss.
Yes, can I just say this? I'm sorry, did my Lord Hodge complete the question?
I did, thank you.
Thank you. You're reducing construction to a very arid exercise by these principles which you're elucidating at great speed. When you get to Glanstoff, it's quite clear that the Lord Chancellor was not at all of the view that the clause should be interpreted so as to expose the contractor to an indefinite and infinite liability for liquidated damages. And that must surely have coloured his approach to the construction. He was looking for a workable / commercial result.
Yes, and I wouldn't disagree with my lady's analysis of that. And when I get to the way in which we say this clause works and why it works as it does, my lady's observations very much dovetail in with the way in which I propose to put it. Can I just, I hope I'm not, in the light of my lady's observation, taking it too fast. I'm conscious of time, and I'm also conscious that the court will want me to get to the actual clause itself. I see my Lord Legate's hand up.
While you're still in the warm-up phase, Mr. Darling, in terms of relevant context, do you agree that the legal context is part of the relevant context and that the parties should be taken to have been well aware of the rules of English contract law that govern the effects of termination of a contract?
Yes.
Thank you.
I was then going to say that in the canter, as it were, that in Gallop, I apologise, that there are, I accept, notwithstanding the fact that there's questions of general principles of construction, there are many pots of specialism, like in the construction context, all of that law about acts of prevention and the time being set at large, and also demurrage in shipping. But in general, we say that unless there is some very special area that has grown up, that is a question of construing all of the contracts in context. And when we look at some of the devices that the parties have used in other cases, we will see that that can produce consequences that are, in some respects, difficult to make work. Third section, there's been much debate about what is meant by accrued right and how the concept of accrued right on termination fits in to the clause in this case. Can I make two things clear at the start? First, we do not say that there was an accrued right to liquidated damages before acceptance, which was then extinguished by termination. It is possible for there to be clauses that would achieve that effect, but our case is not that termination extinguished an accrued right, rather that there was no accrued right at termination. Second, that what the key for whether an accrued right exists or not is the test of unconditionally acquired. And that may prove to be of some significance depending upon how the court analyses Article 5.3, because we say that there is no, on any basis, unconditional accrued right prior to acceptance of individual milestones. The reference, the case that any of my lords would like to have it for their notes. This is nicely set out in the, I respectfully say, in the decision of Mrs. Justice Prakash in the LW Infrastructure case in Singapore at pages 1013 to 1014 of the bundle, following the decisions in Hearst and the Bank of Boston. Mr. Howells referred to the effect of our case being that the effect of termination was to cause the accrued right to expire. It's helpful of him to put it in that way because it gives me the opportunity to say, no, our case is not that the right expired. Our case is that the right only came into existence at the time of acceptance. That comes from the wording of Article 5.3, and we say that when one looks at Article 5.3, there is no such unconditional accrued right until there has been acceptance. At this point, before I turn to the words of Article 5.3, might I draw attention to the fact that, or to some of the features of this clause. If the court would be good enough to look at it at page 741 of the bundle. First, if I may just, I hope to provide the foundation of my submissions, take a couple of minutes just to look at the words of this clause. First chunk, if the contractor fails to deliver work within the time specified. Now, the time specified, everyone accepts, are the milestone dates for the phases and sub-phases, I call them, which are set out in the agreed statement of facts. They were, in fact, agreed post-contractually, but everyone has proceeded on the basis that the time specified is that in the tables that the court sees in the agreed statement of facts. Then secondly, important words, and the delay has not been introduced by PTT. Those are important words for a reason I'll come to in a moment, but they contrast, interestingly, with the words in 5.2, which refer to something a little bit different, not attainable to a delay out of the control of the contractor. So there's two separate tests in those two different clauses, but the one here is, the question is, has the delay been introduced by PTT? Once those two conditions have been satisfied, i.e. non-delivery and delay not being introduced, contractor shall be liable to pay the penalty at the rate of 0.1% of undelivered work per day of delay from the due date for delivery up to the date PTT accepts such work. Now, I'll come to my submissions on the way up to the date PTT accepts such work in a moment. But can I draw attention to two features of that clause? Firstly, that clause makes no provision for how or when delay being introduced by PTT is to be taken account of. There is no mechanism for consideration by whom, when, or in what circumstances. There's certainly no provision for there to be a assessment of that sort of a consequence of delay when it is introduced into the project. And I'll come to how that works in a minute. And secondly, there is nowhere in the contract any provision for repayment of these damages if they subsequently are found not to have been due because the delay was not introduced by PTT. We had a little mini illustration of how this might work in this case this morning. Mr. Howells finished 9 minutes late. Mr. Stafford started 9 minutes late and therefore had 9 minutes of delay. And Mr. Stafford was afforded by Lord Hodge an extension of time of 9 minutes. Mr. Stafford, in fact, to use an expression used often in building contracts, accelerated and was able then to reduce, in fact, not only to reduce the delay, I think, in fact, to eliminate it. And it was therefore not possible at the moment that the delay was introduced by Mr. Howells' 9 minute delay in finishing to assess the impact of that on completion. And in those circumstances, I'll give an illustration relevant to the case in a second, but but it illustrates my basic point that when delay is introduced into a contract, it is not possible to assess, or very often not possible, and certainly can't be agreed in advance to be possible, to assess the impact of that until there has been completion, and in this case, acceptance. If I can take this illustration, on day one of a contract, let's assume that this milestone is a 10-day exercise, starts on day one, and the time specified is completion on day 10. On day 6, the employer introduces the employer, PTT, to use the words of the contract, introduces a delay. You get to the end of day 10, and therefore prima facie, the contractor, triple point, would have failed to deliver the work within the time specified. If my learned friend is right, liquidated damages would then become due for 1 day on the morning of the 11th. But of course, whether the 1 day delay instructed by PTT has had the effect of causing any delay, 1 day's delay or more delay, because one knows that primary delay can cause more delay or less delay in completion than the number of days it actually causes in the first place, then on day 11, it is not possible to know whether the contractor is liable to liquidated damages. Now, in fact, in some of the other forms of contract that are referred to, they do introduce a procedure for interim applications for extension of time. They introduce a procedure for architects certifying that the works ought by the particular date to have been completed, even though they aren't yet themselves actually finished. But here, you have absolutely nothing. But no mechanism, no timing, and on day 11, the employer would be prima facie entitled to his liquidated damages, and there'd be no capacity, not only no procedural capacity, but in many cases no substantive capacity to assess that delay. And if the employer has allegedly this accrued right on the morning of day 11, then the effect of that would be that the contractor was obliged to pay, and we'll come to the difference between pay and deduct in a moment, to pay liquidated damages immediately, but there would then be no mechanism for repayment. My Lord Legger.
That there may be, sorry, I can see there may be some cases where there's a dispute about whether the contractor has introduced delay, and that may mean you can't know for sure on day 11 whether the liability is accrued or not. But in principle, where those conditions are met, then the clause very simply says, doesn't it, that where those two conditions are met, there is the liability to pay.
My Lord's question, if I may respectfully say so, deals with one limb of the two limbs. There are 2 points about the timing of the consideration. One is that there is no time specified, but secondly, that very often the impact of a delay on day 6 on completion by day 10 or 11 may well not be then capable of being ascertained. Not in the sense of a process, but that what the actual impact is will not then have become clear. Because
do you mean the impact in terms of loss? Because we're liquidating the damages here.
No. I mean the impact in terms of time.
We know there is a delay because delay starts when the time specified arrives and expires. But the question is whether it's been introduced by PTT.
No, my Lord, with respect, that's wrong. For this reason, when if there is a single delay of 1 day to an activity during a project, it does not then follow that 1 day's activity delay produces 1 day's delay in completion. It depends upon its impact on the works. It may, in fact, 1 day's delay introduced by PTT on day 6 may, in fact, have no impact because it may not be on the critical path within the project, or it may cause greater delay because it may cause other activities themselves to be delayed, which then causes further knock-on delay. It's not a question of timing of assessment. In construction contracts and contracts of this sort, you cannot assess ultimately delay until the project is complete. I
still haven't followed it, so I have to explain it more clearly. There are milestones for delivering work.
I'm talking about within one milestone, my Lord.
Yes, within one milestone, and the date arrives, the time specified arrives, and the contractor hasn't delivered that work.
Yes.
Every day which passes after that is delay, isn't it, beyond that time specified. We may have an argument about what caused it, but it is delay beyond the time specified.
Yes, so far so good.
Well, then isn't the only question whether there might be an argument still to be had about whether that delay was being introduced by PTT or not?
Yes, and what I'm saying is that very often that question will not be capable of being answered on day 11.
Okay.
Because the way in which, and the reason that because if you cause a delay to an activity, assume that this is all organised.
I take your point. I'm quite happy to accept that, Mr. Darling. All that means is, doesn't it, that if the PTT claims that it's entitled to liquidated damages, there may be a dispute about that, and the contractor may be saying, no, we're not liable to pay you liquidated damages because you introduced the delay.
No, but that's my point, my Lord, and I hope if I make myself clear, I apologise. Point is that that's a question that may not be capable of being answered on day 11 because the impact of the delay will not have been fully worked through in the construction process in some cases. If you have take the simplest case, where it wouldn't be a problem, is if work is stopped on 1 day and there is then no impact, no other impact outside that, and all it does is moves everything back 1 day. But that isn't the nature of these sorts of contracts. What you have is programs of work where 1 day's delay in an activity may cause much more delay or much less delay, and that impact is only accessible, only happens and is only accessible after the completion date. And that's the key point I'm trying to make.
I see. So you're saying that whether or not something done by PTT can be treated as a cause of that delay may not be able to be explained.
You'd be able to identify whether it was something done by PTT that was capable of causing delay, but the extent of that delay in many cases would not be capable, wouldn't have become manifest, and therefore not being capable of being established. I'm trying to give a very simple illustration for clarity's purposes, but when one is looking at it's clear that what's called primary delay or activity delay has different impacts on completion depending upon the construction processes involved.
Lord Sales has a question.
Yes, I think it's really just pursuing the same point. I mean, I can well understand that if you've got delay beyond the milestone, prima facie, the Article 5.3 seems to come into effect, but the contractor may raise a dispute about the delay having been introduced by PTT.
But
isn't the effect of that, well, two things. First, I can see that you may get to the day after or the day of the milestone or the day after the milestone date, day 11 or day 11, and you can't tell at that time whether there is an accrued right, but that is still consistent with there being an accrued right. It's just that you need some process of determination to resolve that dispute, which one party has raised. And sorry, just to put the second point I wanted to ask you was, you said that you can only assess after the completion date whether the delay is introduced by PTT, but there may be many cases where you can determine that at an earlier point in time. There's no necessary connection between waiting to the completion date and then doing the causative assessment that is required under Article 5.3. Why can't you do that at any time when it's possible to resolve that dispute?
Because and I'm sure the fault is mine for not explaining it sufficiently clearly, and I apologise for that. I entirely accept that in probably all cases, you'd be able to identify whether an event was introduced as a matter of fact by PTT, and therefore there's no difficulty of knowing that on what I'm calling day 11. Firstly. Secondly, I also accept that in some cases the effect of the delay on day 6 will be capable of being that the effect will have happened, and the effect on completion will be then A, accrued, and B, capable of being ascertained in some cases. And the illustration I gave there of everyone stops work for a single day on day 6 on the instruction of PTT, work starts again on day 7 as if it was day 6. Everyone knows on day 11 that one day has been lost, and the impact is then known and assessed. But if, for example, PTT says, use a different supplier for this on day 6, and by day 10 the different supplier hasn't produced. On day 11, you don't know, that no one knows, because the impact hasn't yet crystallized. You know there's a continuing delay caused by PTT's instruction on day 6, which may be lasting as far as day 11. You'd need to be thinking at the same time as to whether there'd been other events that had shortened the delay, but you would not be able to know. It wouldn't be a question of timing, it would be a question of the impact not at that stage having crystallized, because it is not a simple case of one day's delay at the start causes one day's delay at the end. It depends upon the impact on the construction activities, whether it's software or building a bridge. And in those circumstances, the effect, and there's a, as your lordships will, my lady will know, there's a complex industry of mini industry of programmers and delay experts who look at what impact of delay on completion is, of delay on particular activities during the parts and process of it. And there are ways that they do it. Sometimes they're prospective, sometimes they're retrospective, but ultimately you can't know with clarity or certainty what the impact of a delaying event is on completion until completion has occurred. And that, in my submission, is an important feature of this case, particularly bearing in mind the absence of the extension of time clause.
Yes, thank you.
You can have other delays which make it perfectly possible to determine when the delay is introduced by PTT. May be perfectly obvious, but even so, it's still important that the right accrues when at an earlier date, because that may affect the accrual of interest on payments.
Well, Milady, that's right, but that's why when we look at this contract, these are part of the indicators that tell you that for interest purposes and for every other purpose, the entitlement to liquidated damages accrues on acceptance, and therefore that provides the starting date for interest, and that is for this reason the bargain that the parties have undertaken, and there are, in my submission, good reasons for it. And again, assume, so if I put it in this way, on day 11, it not being capable of being known on that day whether that is a day of culpable delay or not, because the impact of PTT's actions not yet being capable of being established, and money then is called upon to be paid. Mr. Howells has a point on that, which I'll deal with separately. Money is then called upon to be paid. What then happens, I rhetorically ask, by way of assessment and repayment? Because the contract doesn't provide for that. And the reason the contract doesn't provide for that is it anticipates what I call wash-up on acceptance, which wash-up both triggers the right to payment and also triggers the assessment of the amount of the delay, if any, and the amount that qualifies within Article 5.3.
Sorry, one more question before you move on, Mr. Donning.
Yes, my lord.
I mean, in this case, completion was never reached because the contract terminated.
Yes.
But that didn't make it impossible to calculate the liquidated damages, did it? I mean, they have been calculated, and we know what they are.
My lord, what?
For each day up between the time specified and termination.
But my lord, that doesn't help, because all that does is says that on the facts of this particular case, the fundamental difficulty which I identified didn't in fact apply. And of course, time has then run on. What we are talking about is the question, and I think it's worth reducing it down to this level. The question is, in the period between the time specified on the one hand and the acceptance on the other, during that period, is the employer, PTT, entitled to sue in this particular contract for its liquidated damages, or is it required to wait until there has been acceptance? We say that that is obviously the logical consequence, commercially sensible consequence, because at that moment, the liquidated damages, the delay not being introduced by PTT will be capable of being assessed, and the absence of any repayment provision then becomes of no significance. So we say that it all works nicely in this rather basic, simple contract, and that those factors point very much in favour of accrual on acceptance rather than accrual at 0001 on day 11 in the analysis that I gave.
Well, that might work very nicely for you if that's what the contract said, but unfortunately for you, it says that liability to pay arises if two things happen, and unless you can show that the delay was introduced by PTT, then those things have happened. And you've got a liability to pay, isn't it as simple as that?
Well, my lord, no, it's not. I won't repeat my point about the delay not being capable of being assessed at that date. But then you move forward. Your lordship's analysis, if I respectfully say so, doesn't then take account of the words which A, attracted the Court of Appeal and were said to follow from Glanstoff, etc. But the words which on their own construction show, which I'm coming to, are undelivered work per day of delay from the due date for delivery, and then the words up to the date PTT accepts such work. Now, Sir Rupert Jackson this was ultimately the thrust of Sir Rupert's decision at page 156 of the bundle, and one of the things I accept that when one is construing this contract, this is that the words up to the date when PTT accepts are important to the construction. One of the difficulties one has in this area, and it's one of the reasons why I wouldn't, with respect to Sir Rupert, approach the analysis in quite the same way in some respects as he does. What one has to do is to look at the package of circumstances. And my points about the delay being incapable of assessment and the absence of repayment are two of the things that I put into the, your lordships forgive me, lady, into the bucket of construction with the words up to the date of PTT accepts such work, and it's their combined effect when one is asking, are these parties to have been taken to have intended the liquidated damages start at the accrue unconditionally, to use the words of the authorities, on day 11 from my analysis, or whether they await acceptance. I place strong reliance on those factors, but I also place strong reliance, I don't want to overstate it, I put them into my construction bucket with the words up to the date PTT accepts such work, and it's their combined effect.
But the words up to are opposite against you, aren't they, Mr. Darling? Because they're an end date, they're not a start date. That's when the daily rate stops running.
Well, my lord, why would one need to have that? If I rhetorically turn the question around, what purpose do those words provide? Because if they're unnecessary, if your lordship's construction is right, you don't need such words, because that is obvious as soon as that they would be effectively mere surplusage, because the entitlement couldn't run beyond that date in any event. So when one's looking at the factors,
you might have an argument. You might have an argument about whether, if the contractor says he's completed the work, but
I'm sorry, I didn't hear that. I apologise to my lord.
Sorry, you might have an argument that the contractor might say, "Well, I've completed the work," and PTT will say, "Well, we haven't accepted it yet, so you haven't, in fact, delivered it."
But that then begs the question as to whether they.
This makes it clear it runs until acceptance by PTT. Well, it doesn't stop on when the contractor says it's delivered the work.
But PTT's acceptance would have to be correct, and it adds nothing to completion, because PTT is obliged to accept it if it's complete. And so therefore, those are words that actually make no difference at all, because it's not only for PTT to say, these works are complete, but we're not going to accept them. There is ultimately no distinction to be drawn there. And the question that arises is as to whether or not, and I entirely accept my lord's approach, and don't with respect accept the way in which the approach leads to the conclusion that my lord's postulating, but it's certainly right that what one is looking at is the clues from these particular words. And of course, if I can jump forward to a later part of my argument so as to make it, that one of the reasons it dovetails in so nicely, I've got Mr. Houser's point about pay and deduct that I'll deal with, as it were, immediately after this point, but there is a perfectly clear symmetry here. What one has is this process whereby whereby you have to assess whether there has been, whether and to what extent there's been delay introduced by PTT. You do that at the moment of completion when you are able to do it, and you then have the easy route to deal with both financial entitlement, because it's the milestone that accrues the money, and it's also the complete on the occurrence of the milestone that you end up with the money paid from which you can then deduct the liquidated damages. And in my submission, that what the parties have done here is eminently sensible. They're not going to have any of the certification nonsense or third-party involvement or anything along those lines. They're going to allow the completion of the milestone, enable the assessment of the delay, and then having set the requirement that the work has to be accepted by the words up to the date PTT accepts it, then enable the milestone to be accounted for and payment then to be made. And in my submission, that makes absolutely perfect commercial sense. Now, of course, there are ramifications to that, which may mean, and my Lord Legate gave this illustration in argument and question to Mr. Howells about the accrual of the cause of action in 6 months, etc., etc. But in these forms of contract, you cannot identify each and every potential situation and make these clauses fit with them. This is a rudimentary contract with many difficulties. What one is trying to do is to work out the best, what is, by the Wood principles of construction, the best way that fits them all together. And in my submission, the combined effect of these various factors and the words, as identified by Sir Rupert in the Court of Appeal, have that combined effect. And my Lord, yes.
Which are the words of conditionality that you rely on in the clause? I mean, we've got an if at the start with two things that follow it. Where are the words that say, provided that PTT accepts the work, or if it accepts the work, or unless it doesn't accept the work? Is there any such word in the clause, or do you just say we have to read it in?
No, my Lord, I don't say you have to read it in. What I say is you have to ask, what is the nature of the right conferred? The conditionality which my Lord correctly refers, i.e. the precondition to any award, are the two subclauses at the start. If the contractor fails to deliver work and the delay has not been introduced. And they are, whether one labels them conditionality or preconditions, or they are the things that have to happen. They are the things that trigger the entitlement. You then ask, what is the substantive entitlement? And the substantive entitlement is substantive liability on the part of the contractor, substantive entitlement on the part of the employer is damages at the rate of 0.1%. Then the keywords from the due date for delivery up to the date PTT accepts such work. And as Sir Rupert says in paragraph 112, that's not conditionality, that's definition of the nature of the entitlement. So, my Lord, I wouldn't say that it's not phrased by me in terms of a condition, it's phrased in terms of the description of the entitlement. And this is important because what the contract does is make the contractor liable to pay sums in certain specified circumstances. And those specified circumstances, first of all, require the trigger, but then you have to ask very carefully, what is the liability which the contractor has contracted to undertake? And in my submission, Sir Rupert correctly described that at page 112, identifying the ambit of the liability that the contractor undertook. And I've given, though not I'm sure yet to the satisfaction of my Lord, the reasons why, the commercial reasons why, when one is construing all the different contracts, this is one of those contracts that has where the trigger is acceptance rather than an earlier date. And in that context, if I can just mention as I go past, I promised to refer to Mr. Howells' pay and deduct point, and when one shelves a point several times, it may give the wrong impression. I want to just hit that on the head if I can. Mr. Howells says if its liquidated damages are going to be at completion, they would always be deducted, and therefore, forensic point, pay there's something more than pay, and therefore that is inconsistent with our determination, our construction. We respectfully say that's just not right. The employer has the option, and it's a well-known concept in contracts of this type, the employer has the option to deduct liquidated damages. but very often for commercial reasons, employers will choose at that point not to deprive the contractor of his cash flow, but will then seek later to require payment. So the fact that you would normally deduct doesn't make the word pay for a second redundant. So there is nothing in that construction against us. So what we say is that when one looks at the clause, the commercial, the words, the concepts, the commerciality of it all lead to ultimately to the same conclusion. Now, like in so many other parts of this contract, the parties, to use Sir Rupert's words to which I cling, are the draftsman didn't make it easy for us all to construe this. Now, of course, it would have been easier if the parties had said in their contract, liquidated damages will accrue as soon as completion as soon as there is delay. Some contracts do that. Some contracts provide certification by the architect of culpable delay immediately the completion date has passed. Some don't. Some provide the opposite. That is very much a question of what the contracting parties there choose to do. They could have put it in absolute clear terms in either direction. Like with the rest of this contract, they haven't, and in those circumstances, what one is doing is gathering together all the different pointers and indicators. I'll come to the so-called orthodoxy in a moment, if I may, but ultimately, we say that the combined effect of these various different factors, my lords, the court's questions have obviously been extremely helpful. Could I just have a moment to just identify the bullet point, the points that I wanted to make, some of which I've made already in answer to my lord's questions. First point is my point that, which my Lord Leggatt and I discussed a moment ago, about whether the words up to the date PTT accepts such work would otherwise be surplusage. Second is my point that about assessment as to whether or not the effect of delay during the time before the time specified has had impact, and if so, what extent, I've also made. Thirdly, my point about there being no mechanism for repayment. Fourthly, that damages pre-acceptance would necessarily be provisional, because they could not then, because it could not be said that they were that was going to be the ultimate position, and therefore they could not be regarded as in any sense unqualified right, even if I was otherwise wrong as to the way in which the words worked. And finally, I point to the sheer simplicity of all of this. In construction contracts, and Mr. Howes has produced some of them, and there are, of course, whole plethora, both in this jurisdiction and across the world within the various different areas. If you want to have mechanisms that deal with interim assessment, interim payment, and subsequent repayment, whether provisional or binding until reviewed or whatever, because there are technique after technique after technique that can be used, the parties can choose those. The question, they haven't chosen any of them here. What they've done is produced a simple contract with a simple process linked in a whole number of different ways to completion and acceptance, rather than to the period upon which the first day upon which the contractual completion date has been exceeded. Now, can I then, bearing in mind time, can I then deal with Mr.
Lord Leggatt, I think, has a further point before you...
Sorry, my lord.
Sorry, I'm interrupting you again, Mr. Lolling, but it's maybe because I'm coming from a different general experience, or maybe there is a point about industries here, but I'm used to demurrage in a shipping context as liquidated, most common form of liquidated damages, I think, which almost invariably, I think invariably accrues from day to day. Now,
yes, but
examples, could you just, and it might help if you could just show me one example of a common clause in the construction context where liquidated damages don't accrue from day to day, but they're calculated on the basis of an entire period, where you say this clause operates. But is there one that's a very clear example of that? Shows what you say.
Well, we didn't. I'm sorry, my lord, we didn't adopt the example approach. My lord's question related to one that was on a day-to-day basis.
No, well, I'm saying that I'm familiar with demurrage shipping contracts where demurrage always accrues day to day. I'm not familiar with a liquidated damages clause that does not accrue day to day, but accrues only in respect of an entire period at the end of that period. Now, if you say that's a perfectly common form of clause, the one you say is in the construction context, I'd just like to see an example of a clause which you say this is substantively equivalent to, which shows that it's perfectly normal in a construction context or perhaps a technology IT context to have, as it were, a lump sum whole period global liquidated damages assessment, albeit that the rate is calculated as a daily rate. But you say the liability doesn't accrue as a daily liability.
If my lord, I was to say this one, I'm sure my lord wouldn't regard that as an entirely satisfactory answer. I don't think there is one where there are words. What one is envisaging is, what my lord's question is envisaging, is a standard form that clearly states that liquidated damages will not accrue until completion. What I can't show you one of those. What I can show you is clauses where, and it's a page. Mr. Howells is the one who's adduced these documents, adduced these standard forms. He's adduced page 77 of the bundle, which is part of the JCT design and build contract. Now, wouldn't have been the one I would have chosen, but there is but I can illustrate my point quite neatly by reference to it. It's clause 229 of that contract, and the proviso there is that the employer has issued a non-completion notice for the works for a section. And when one looks at what is meant by a non-completion notice, it's clear in that contract that is a non-completion notice that is capable of being issued immediately after the date for completion, whilst the works remain uncompleted. So, my lord, there are cases where the parties have done that, but they've done it in a way that then it introduces a process of process that involves certification. I think that if I could pass on and while I do that, I'll have a quick check of the authority, see if I can give your lordship a better example. But perhaps your lordship would enable me to do that, as it were, towards the end rather than immediately.
Yeah, of course.
Lordship, give me a moment. If I could take advantage of my Lord Hodges' opportunity. In fact, I know that my lord is going to suggest that there needs to be a 5-minute break. Probably, I don't know whether my lord wants one during the course of this afternoon.
We don't normally have in the course of the afternoon, but Mr. Darling, if you're being asked to do research and you cannot do it adequately on your feet or on your seat at the moment, then if you need an opportunity to produce a written document within 7 days or something, the court would probably be disposed towards that.
I'm very grateful, because I see some of the authority. The clauses here come in a whole number of different ways, and I'd be keen to give my Lord Legate, as it were, the best illustration that I can. So I'll proceed, if I may, upon that basis.
Yes, I mean there are numerous standard clauses, and they are in different terms. So I don't want to bring them on you.
My Lord, I think it's right that I not face, because it's the fact, is that one of the problems, which I understand the point made by Mr. Howells, but I don't accept it. When I come on to my conclusions, I will be saying that there isn't an orthodoxy determined by the industry. There are contracts that the court construes, and that will produce different results. And there's no way around that. And if the industry doesn't like the outcome and wants to standardize, then there are a number of ways in which they can do that. So the first point they make is that the word pay is redundant. I've dealt with that. Second point they make is that there's somehow there's some inconsistency between completion on the one hand and payment for milestones and liquidated damages on the other. We simply don't understand that point, because in fact we say that the fact that they are both triggered by the same event is part of the very sensible commercial consequence that we identified. Thirdly, Mr. Howells then refers to the words undelivered in the proviso to Article 5.3. Again, that doesn't help, because all the word undelivered means is not yet having achieved completion or acceptance. And everyone accepts that is ultimately the period to be considered for delay. The question is not whether it is to be considered for delay, but rather when. The fact that something is undelivered makes it eligible for liquidated damages, but the question is not whether it is eligible for liquidated damages, but at what point that eligibility turns into the unconditional accrued right. So the use of the word undelivered and the concept there takes ultimately Mr. Howell's analysis no further. We say that the approach that they adopt is minimalist and word focused. And for the reasons we've given, the individual points are wrong, but their whole approach, we say, is wrong. The question for the court is to construe, in the light, as Sir Rupert Jackson did in the Court of Appeal, the way in which Article 5.3 works. Sir Rupert was right to look at the various different clauses and to canter, gallop, whatever label one attaches through the authorities. There are a whole number of reasons for him being right to do that. The most obvious one is the words of my Lord Hodge in Wood and Capita about how this has been dealt with in other contracts, but also because this is an area of law which is perhaps not, or an area of construction which hasn't necessarily had the microscope on it the way that other areas of contractual construction in these sorts of contracts have had. But ultimately, as Sir Rupert himself acknowledged in the paragraph I've already taken you to, this comes down to a question of construction of the individual clause that arises in this case, or the individual contract, I beg your pardon, the clause in the context of the contract and the exercise of contractual construction. If I can then move on to the standard form position more generally, PTT criticised the Court of Appeal on 3 grounds. First, they say that the Court of Appeal misconstrued Glantzoff. Second, they say that the result of the appeal is inconsistent with decided cases on standard forms, and they refer to the fact that there appears to be, they say, some form of so-called orthodoxy. And third, they say that if correct, if the Court of Appeal is correct, there will be chaos. In our submission, neither of those 3 points is correct. We do not say that it's necessary for this court to decide whether Glantzoff was or was not correctly decided and whether or not it should or should not be followed. Again, Glantzoff is a case that turns upon its own facts and provisions. Of course, we accept that if there were identical circumstances, identical contract, identical circumstances, unless it was held to have been wrongly decided and departed from, it would bind them, but those were earlier forms of contract. We respectfully say that, in fact, so we don't need to take a position on Glantzoff, but if we are called upon to take a position on Glantzoff, we submit that it was correctly decided and that it is not, and that it should not be distinguished from the facts of this case. If I can take the correctly decided point first, we are not concerned here with the alternative remedy ground of decision. We are concerned with the alternative ground on the construction of clause 24. Mr. Howell says that the Court of, I beg his pardon, the House of Lords didn't grapple with clause 24. We say not so. Both the Lord Chancellor and Lord Shaw both grappled with and dealt with its terms. And the reasoning in Glantzoff, we say, shouldn't be distinguished from this case, and should in fact be regarded as binding or of help to this factual situation as well. Sir Rupert expressly made that point at paragraph 107 of the judgment of the Court of Appeal. Now, when my learned friend Mr. Howes was making his submissions, there were various interchanges between him and my lady and my lords, and I'll just pick up, if I may, the points that emerged from that. 2 points I wanted to make about the timing of the 2 points emerged in the discussion between my learned friend and my lady and my lords. The first was that the termination occurred before the completion date, and the second was that the delay that occurred, the delay for which liquidated damages were being claimed, was delay in completion by the alternative contractor. We say that neither of those points make any difference, as Sir Rupert said at paragraph 107. Firstly, the fact that whether the original contractor was determined before or after contractual completion date makes no difference. If he had been terminated a little bit later, then the effect of that would simply be that there would have been a small amount of liquidated damages, and the balance of the period would have made ultimately no difference. But the breach, whether before or after completion, is one that caused delay in the completion of the project. This is not a complaint about delay by the replacement contractor. It's a complaint about, in principle, it's a complaint about delay as against the original completion date, which the original contractor failed to meet. So in those circumstances, the court's construction in Glanstoff of clause 24 as requiring completion, and therefore the right not being an accrued right at the time of termination, was in those circumstances sufficient to make Glanstoff correctly decided, and not distinguishable from the present case. But we are keen to emphasize that we regard Glanstoff as a case that has helped the reasoning at most, and I stress at most, rather than one that was determinative.
Yes, could I just add one thing at this point, yes. Mr. Darling? I mean, when the court in Wood said that looking at other similar contractual terms might assist, that was in the context of there being a lack of clarity of what the purpose of a particular provision was, and was looking to similar terms in other contracts to ascertain purpose. It was not attempting to give credibility to the idea that a way of contractual construction is to go through a whole lot of contracts and find which is the most similar. But I think you appreciate that.
My lord, I do, and it's not part of my case as to say whether the approach of Sir Rupert was the helpful one to the development of this, the construction of this contract. I think there was a sense, if one reads the history of the court inviting authorities, the court being interested in seeing how this had been dealt with elsewhere, because there were obviously, it was quite clear, as has been put extrajudicially in various articles, the authorities here were putting it conversationally from one of the articles, all over the shop. And that is as much true of categories 2 and category 3. And different judges had been called upon to decide these issues in this territory, because not each of them turns on their own contract in each territory. And to be frank, if one looks at the way in which the issues have arisen in cases and the way they've been dealt with, one wouldn't, if one was doing a masterclass in presentation of points, that they appear to have been dealt with quite cursorily in some cases, because they by their nature, these points come to the end of long cases. And if you look at some of the judgments, they are that they don't get the, well, they're certainly not getting the level of analysis that they're getting from the parties in this case, nor the level of analysis ultimately in most cases that it got from the Court of Appeal after Sir Rupert had called for the authorities that the parties had not provided him with. Of course, this point not being one that the judge decided, and therefore therefore, that is why, and if I'm going to be completely candid about it, I was using would and capital, and if I've taken it too far, I apologise, as it were, a reason to recognise the legitimacy of looking at some of the cases in this particularly unusual set of facts. But what my Lord says, I respectfully, as your Lordship says, is where I start from in any event.
Yes, Lord Sales.
Yes, sorry, just on the Glansdorf thing, I just wanted to check that I'd understood the significance of the timetable, that the first contractor was removed from the project before the date for completion. As I've understood it so far, but tell me if I'm wrong, the effect of that was that there was simply no accrued right under the liquidated damage clause in his case, because the accrued right could only occur insofar as there was relevant delay by him after the date of completion. Have I understood that correctly?
That's what the court said, because that's what the House of the Court of Session and then the House of Lords said, because what was claimed, so the contractor is, to use the technical term, ousted, and marvellous expression, and before the completion date. There's then the appointment of a replacement contractor, and they then contrasted the date upon which the replacement contractor completed with the date in the original contract.
Yeah. So might it not be said that that's a completely different situation from the one that we're dealing with, where what is being said against you is that there were accrued rights by the date of termination?
And the question that arises as to whether the reasoning in Glansoff it means that there helps the consideration of the question in this case as to whether there was or was not an accrued right. And my Lord's analysis is right. And the question is, in Glansoff, as Sir Rupert says in so the principle that Sir Rupert takes from Glansoff in paragraph 112 is that in Glansoff, the reasoning supports the proposition that where the contractor never hands over the completed work, then clause 24 does not apply. And it is that principle that Sir Rupert takes. My Lord Sales is right in saying that occurred in factual circumstances where the original contractor not only never handed completed work over, but was ousted before the contractual completion day. And the issue is whether that makes any difference.
Thank you very much.
I think
we
better let you develop your submissions because time is ticking off.
Yes, I'm happily. All I've got left is a bit on the standard forms and a bit entitled chaos, my lord, which may seem may provide some assistance to the court.
I'll give you 10 minutes for those topics.
I shall take 5 for each, and I'm very grateful to my lord. I just wanted to talk for a moment without avoiding my Lord Legate's question as to the standard forms. I just wanted to make some points about standard forms. When you look at standard construction contracts, there are a whole number of devices that they use. How they work, what they are matters for the construction and content of each contract. But very often they include an express procedure for accrual involving certification by an architect, or they involve express provisions which exactly say when the liquidated damages are triggered. Then sometimes they have provisions for considering on an interim basis or a final basis, or on an interim and then another final basis, whether there should be a variation or extension to the time for completion. There are review provisions. In the JCT, there's a 3-month review provision after practical completion, and they have provisions for liquidated damages. Provisions for the repayment of the liquidated damages, either in whole or in part. And there are complex procedures. Each of these contracts has their own complex procedure. I'm sorry, that overstated, has their own procedure, some more complex than others. And when one is thinking about Mr. Howell's point about the so-called orthodoxy, then in my submission, you have to bear in mind that these so-called standard forms, and they're standard forms in their own narrow respects, are of course ultimately creatures of their own context, words, etc., etc. So we say that when the court is construing this clause, the absence of those techniques is a factor, and devices and systems is a device. If, for example, there'd been a provision in this contract which said, as soon as the completion date is reached, the PTT will certify the date upon which completion ought to have been achieved. So I draft on my feet, as it were. Those sorts of provisions, if they existed, would have dealt with it. But we are faced here with a simple provision, and without repeating or putting back to going back over the submissions of submissions I made in response to my Lord Legate's questions, the contractual procedure and words mean that the absence of any of these technical devices is, we say, particularly significant. And I then finally, in the I think 4 minutes that I have allowed, want to just deal with the in terrorem point. Mr. Howells says that you must construe this clause as he contends, because the decision of the Court of Appeal, on the one hand, offends an orthodoxy in the construction industry, and whether he says that it offends an orthodoxy in the IT industry, I know not, but an orthodoxy, and that it will, if implemented, it will cause chaos. Well, there hasn't been chaos, not at least in construction contracts, since the decision of the Court of Appeal, and we know that that when courts make decisions as to what standard forms mean, then the developers and promoters of these standard forms have committees that then consider what amendments need, if any, to be made to reflect what the industry would like the contract to mean, reflecting the court's decision. Any of us who were involved in the toing and effectively the negotiation between the courts and the JCT standard form over the final certificate provisions and whether they were conclusive or not, will be well familiar with the process whereby such matters are dealt with. The standard form promoters can change their contracts, and the court then construes the changed contract. But in any event, we are very dubious as to whether it is right to say that there is an orthodoxy concerning entitlement to liquidated damages following termination. Yesterday, in the final stage of my preparation, I had a look at the textbooks, Keating, Hudson, Wilmot Smith, Bailey, etc. And there are indications in some of them in one way or the other, but it is not in our submission possible to identify a clear orthodoxy or a clear perception. And indeed, Sir Rupert's analysis demonstrates the problem, because if orthodoxy is category 2, then leaving aside Glansoff, there are an awful lot of cases decided in category 3 by very eminent and well-respected judges, which would be surprising to have if they had so easily ignored the so-called orthodoxy. But even if there is an orthodoxy, it doesn't matter. The question for this court, and for the courts generally, is whether the clauses and the contracts achieve the so-called orthodox result. Courts construe contracts. Reports, whether accurate or not, of general views in particular sections of particular industries about what is orthodox do not. If the court construes a contract in a particular way and gives reasons for that, then they can be amended, if that is what the industry wants. If the parties have not, by their words, subjectively achieved what a particular group wanted, then they can contract differently next time. In fact, the general mischief point doesn't stand up to scrutiny, because one looks at each contract on its own words, concepts and procedures. And I give the illustration again, my lord, of the contract, the JCT contracts, which contain provisions for notice of non-completion. And it's quite clear those notices can be issued on the words of that contract after the completion date, but before completion, i.e. during the period of culpable delay. And that's going to be a very powerful factor in that contract as to why damages can accrue on an interim basis. but each individual contract is different. Ultimately, my lord, yes.
One final question for you, Mr. Darling. I appreciate you didn't appear in the courts below, and the fact you've been brought in now obviously shows how important this point is in the industry. But would it be unfair to put some weight on the fact that it evidently didn't occur to any of the very expert construction lawyers on your side that this was a possible reading of the clause until after the trial?
Well, my lord, I think that's a question, if I'm going to be completely candid, that I have asked myself. And my answer to that is to ask your lordship to turn to the judgment and to look at the list of issues which covers the best part of 2.5 pages when it goes from claim to payment through termination to damages and quantum. Lord, I'll be completely candid as to the reasons for my presence. Your lordship will have seen the way in which Mr. Stafford and I split, notwithstanding our respective positions in seniorities, etc., etc. Mr. Stafford and I split the commercial matters to him and the construction matters to me. And the reason that I was brought in was because these were said, after the decision of the Court of Appeal, these were said to be construction matters upon which some construction experience, and I hope it's had some help, might be thought to be of some help. So the fact is that I think that would be a fair point against our side if I'd appeared below or in front of Mrs. Justice Jefford. But I think with a commercial team rather than a construction team, this is an IT case ultimately, and Sir Rupert, who without doubt one of the leading construction judges of the last 100 years, perhaps gave it more of a construction contract spin than it had had before, notwithstanding that it was this was very much the technology part of the technology and construction court, and Sir Rupert turned it, in my respectful submission, more into construction than technology.
Well, Mr. Darling, I'm not aware of any authority on the constructions of contracts from the House of Lords or this court which has used the selection of counsel as a criterion for a decision.
Well, my lord is right, but of course, amusingly, in this case, when Sir Rupert was looking at the Scottish authorities, he regarded the eminence of the Scottish silks involved as a matter of great significance to his, not analytical significance, but he identified the names of the eminent people that had been involved. I can conclude my submissions, my lord, by making one final point on chaos. It's said that there is some mischief in liquidated damages only being claimable at completion, even if a problem that would not arise in a milestone contract. Very often, payment at completion will be a very sensible way of dealing with it, and the parties may choose to do that rather than having interim rows, and they may choose to have a single wash-up. And of course, it's again a matter of party choice. And I finish, if I may, by highlighting the one point that I am concerned should not slip through the analysis, which is that in many cases, it will be remarkably to the employer that the employer may, in many cases, if the parties have chosen a low liquidated damages figure, the employer may in fact be very pleased that the liquidated damages do not accrue, because he then gets the opportunity, particularly as the innocent party, he then gets the opportunity to avoid the limitation which the parties have then thrown at it, the parties have would otherwise bind the parties. He gets the opportunity to recover his real loss in those circumstances and is not confined to the limit that the parties have agreed. So the liquidated damages not being claimable, not accruing and not yet being claimable, is as capable as operating in the employer's benefit and to the employer's advantage as it is to the contractors. And I'm just keen that, by way of final observation, taken slightly out of context, that, in my respectful submission, very important point I'm just given the I just put in to remind, if I respectfully do, the court that this is not a pro-contractor, anti-employer point. Which way it goes depends upon the commercial bargain in each individual case.
Thank you.
Unless I can help my lady, my lords, any further, those are my submissions.
No, your time is up anyway. Thank you very much. Mr. Hunt.
Well, thank you. The time available to me, I'd like, if I may, to briefly respond to some of the points raised by Mr. Darling. I'm not as eminent as Mr. Darling in construction, of course, but I have a bit of experience. And if I may look at 3 particular points. One, the accrual from day-to-day point that my Lord Legate raised with Mr. Darling. I think there's an invitation for Mr. Darling to go away and try and find a contract somewhere which refers to delay, liquidated damages, liabilities, or entitlements being calculated on lumps on periods of time rather than day to day. I can't think of one, but if he does find one, I think I would suggest your lordships turn back to Article 5.3 this contract and remind ourselves that this contract does provide for the liability liquidated damages to accrue from day to day. 741 is the page. Article 5.3, the liability to pay the penalty at the rate of 0.1% of underwork per day of delay, and that, in my submission, is effectively bang on the demurrage type scenario where what's being said by the contract is you have a liability to pay liquidated damages per day, all insured every day. The point that was made against that is, well, this contract, like a construction contract, I think was being put, one can't tell what the extent of delay might be at any particular point in time, the impact versus assessment. And 2 points arise on that. Firstly, my own friend, with respect, was eliding 2 quite separate issues. The first is the question of the accrual of the entitlement. And that's defined by this contract, as my Lord Legate identified, in the terms of the contract by reference to the liability stated to fall due from the due date, that is the milestone date, and that's the definition of the accrual of the entitlement or the liability, depending on which side you're looking at it from. Questions about ascertainment, so the impact of the facts or behaviours of the parties as to who has caused or not caused delay. Any disputes about that don't go to the question of accrual per se, they go to the ascertainment of the amount of damages, and that would be a question of dispute. So if we postulate as our example a situation in which there is on day 6 a PTT delay and day 10 is our postulated milestone date, on day 12, 13, 14, PTT says, well, triple point, you're 3 days, you're a day late, 2 days late, 3 days late, and I want liquidated damages for that. And PTT triple point say, well, I'm sorry, that's not right. I haven't caused delay. You are the people causing delay. The reason I've missed the milestone date is your delay, at which point the parties fall into dispute. The concept postulated by Mr. Darling is, when he makes his point, there's no means of repayment provided by the contract, of course, doesn't arise, because what you've got is a party-to-party dispute about what the liability is, damages. Once that's resolved, the issues that my own friend put forward as being difficulties or impossibilities to know will be resolved. They'll be resolved by the court in this scenario. Because the court's there to resolve the dispute between the parties. Was there a delay caused by PTT or caused by TPT? And if it's caused by TPT, triple point, that is the respondent here, and the date has passed under Article 5.3, the right liquid damages is accrued, and the court will calculate the amount accrued. And what my learned friend has done is elided 2 separate points. It's the question of accrual with the amount of the ascertainment of the entitlement. And if this is a point which, again, Mrs. Justice Prakash in Singapore dealt with in her judgment, and I can give you the reference to that. She deals with it in a section later in her judgment, which you'll find starting at paragraph 36 on page 1020, and runs forward for the remainder of that section onto page 1021. And I commend Mrs. Justice Prakash's analysis of that point to your lordships. Last very short one, just so there's no misunderstanding. My own friend came back on a point I made about undelivered, the value of undelivered work. With respect to my own friend, I think he may have misunderstood the point I was making. The point I was making was the reference to undelivered work in the last part of Article 8. Article 5.3, apologies, which is the calculation of the amount of damages by reference to both the value of delivered work and the value of undelivered work. And the point I was making was, if you're talking about delivered work, when you mix into the valuation of the amount of damages undelivered work, that's not consistent with the idea. You have to wait till you can look at delivered work. And then the friend's response looked at the first use of the word undelivered, which is part of the clause which forms the definition of the accrual, the accrual of the entitlement to liquidated damages and a calculation of its quantum, which is in the earlier part of the clause. The two aren't related in that sense. If I may then briefly deal with a couple of points from Mr. Stafford's submissions of this morning and earlier this afternoon on the limitation clause. That's Article 12.3, which, my lady and your lordships, will find once again at 745 in the bundle. On a number of occasions, my learned friend Mr. Stafford asserted that the limitation imposed by the second sentence in Article 12.3, which begins a total liability, is effectively an overarching liability to be calculated, to be taken as meaning, effectively a liability set by reference to the total contract price, using total to mean effectively capped at the total contract price. And that's not correct in my submission for the reasons I gave earlier on. When one reads the sentence in full, the total liability, that is the statement of the liability for breach of contract, is defined in the second sentence by reference to identifying that part of the contract price received with respect to the services and deliverables involved. That is, there's not a separate aggregated aggregated cap set at the total amount of the contract price paid. The clause says you must identify the value of the services and deliverables, and that was what led on to my submission that effectively second and third sentences are the same. They're both defining the financial aspect of the limitation in the same way by reference to the value of the services and deliverables. My own friend said, well, lots of services and deliverables go into these things, you have to work this out for yourselves. First point, yes, definitely, we agree with that. There are many services and many deliverables that go into the production of, that form like the practical content of the implementation of this contract. None of them are differentiated in terms of value. I sought to express that to you by reference to the list of services and deliverables in part 23 of the terms of reference in Exhibit 2. But while I don't accept Mr. Stafford's right to point to the technical clarifications document, because that doesn't do the same job, the essential point is the same, we're agreed. There are numerous services, numerous deliverables, none of them are given a separate price. My own friends at Mr. Stafford's submission proceed on the basis, well, for two reasons. One, the total liability point, I say it's wrong. Secondly, the words themselves tell you to try and find a value. This is the point that we've made in our written submissions, which is the problem with the Court of Appeal's approach to mini-caps. We say when, in circumstances where the contract price isn't differentiated by reference to services and deliverables, the position postulated by the Court of Appeal and Mr. Stafford as well now, Mr. Stafford's position, which is, well, work it out amongst yourselves, is not an appropriate or not a sensible way to construe, we say, a limitation clause. That approach simply throws into the air the value of the limitation. Parties will never know what position they're in terms of what the value of the limitation is. What is PTT's, what is Triple Point's liability? Now, one of the main points being made against me by Mr. Stafford was, well, the limitation clause is there to define for both parties in advance their respective entitlements and liabilities, so that both parties can know as a contract what is likely to be their maximum liability. That's as true of the effectively mini-cap approach, understanding what is one's liability for breach of an obligation in respect to the production of a particular document. If that's the way this clause is supposed to work, will be important. But the approach that's been taken by the Court of Appeal and by my learned friends is to say, well, you can never know that. All you know is that if there's a breach in respect to one of those documents or one of those services, at some point somebody will have to work out for you what the limit is of the liability for that service or deliverable, because you can't find it in the contract. So it's not sufficient, we say, simply to leave open in the context of a limitation clause that key factor, which is the definition of the limitation itself. And that points, we say, towards our construction, which is to identify, to see these sentences are both the same, effectively. Sentence 3 explains sentence 2. And in doing so, sentence 3 makes clear that specific remedies are not included within the limitations set by sentence 2. And for our purposes, ultimately, as we said in our written case, and I think I said at the beginning, given the findings that were made by Mrs. Justice Jefford, which was that delay in this case is caused by negligence, the negligent acts of the contractor, actually the answer will flow each way, because the liquidated damages, being our entitlement for delay, would in any event fall within the negligence exception in sentence 4 anyway, we say. But as a matter of the way this clause is constructed, while the wording is very far from clear, the better construction, we say, is to see that specific remedies are excluded from the cap of what you're entitled to have with PTT in the context of liquidated damages, is an entitlement uncapped. You're entitled to have your damages calculated on a daily rate, 0.1% of the value of the undelivered milestone, until the work is accepted, completion. And those words are not, as my own friend Mr. Darling said, surplusage. They do what every liquidated damages clause does. They define the start point of the damages, and they define the end point. The end point is acceptance. Now, as to sentence 4, in the last couple of minutes, my own friend Mr. Stafford's submissions appear to align a number of things. It was suggested that the last sentence, sentence 4 of Article 12.3, was not an attempt to limit contractual liability. That must be wrong, I submit. The reference to the sentence appears in a clause which limits liability, a liability which is defined in full by reference to breaches of contract. That's what the parties have agreed by the first sentence of Article 12.3. The limitations being set in sentences 2 and sentence 3 are limitations on the liability defined by sentence 1, the liability for breach of contract. And the introductory word to sentence 4 is this limitation of liability, referring back to the limitation of liability set immediately before it in the paragraph. That is the limitation of liability set by sentences 2 and sentences 3. One would not say this limitation of liability if one meant there is no limitation of liability for non-contractual breaches. My Lord Sales.
Yes. Can you just help me with the underlying license agreement at page 790?
Yes.
Because I was wondering whether the terms of that license and the fact that it is part of, although a subordinate part of the CTRM agreement, possibly lends some weight to Mr. Stafford's point that I think he put it as the panorama of matters referred to in the last sentence of Article 12.3 went wider than the contract. Because 7.4, under the license, there was an exclusion of liability, or rather, sorry, a cap in relation to liabilities arising under any cause of action whatsoever. So that was, if one just had that, it was capturing non-contractual causes of action and contractual causes of action. And in that context, fraud, gross negligence, and willful misconduct was intended to cover concepts across the whole panorama, so contract and non-contractual. And then if one looked at 10.9, entire agreement on the same page, incidentally, I'm rather taking that the small print is the sort of the standard contractual printing, and the capitals, well, seems to be, well, actually, sorry, I take that back. It doesn't work. I can see it doesn't work. But anyway, obviously, the capitals in 10.9 at the end have been added to try to regulate to some degree the relationship between the cap in 7.4 and the cap in 12.3. And it does, might it be said that it shows that the parties were concerned to regulate or deal with a potential overlap between the two, and to try to explain and minimize conflict between the two. So it's obviously there are problems both ways round for both parties in relation to the construction of this, but I just wanted to get your observations as to whether it might be said that the terms of this license agreement gives some weight to Mr. Stafford's point about the panorama of matters being dealt with in the final sentence of Article 12.3.
So 10.9, I entirely agree. What the parties were trying to do in the capitals was to regulate the relationship between the license agreement and the CTRM, particularly in the context of, I think as my learned friend Mr. Stafford identified, the binding in of this agreement, these standard terms from Triple Point into the contract. The next article, as your lordship I'm sure will remember, in Article 29, the order of precedence says this one sits below, and 10.9 effectively in this contract reflects the order of precedence. You give priority to CTRM contract over what this says when there's inconsistency. And the reason this clause, when one then moves one side back to 7.4, I would suggest doesn't help Mr. Stafford, is because one doesn't see inconsistency. What one sees in 7.4 is a wider limitation, which is what Triple Point clearly was putting forwards in its standard form license agreement for all sorts of liabilities potentially. But the parties would certainly appear they've lifted words, but in choosing how to define the limitation of liability for contractual breach in Article 12.1 in the CTRM contract at the top of the precedence chain, the parties have said of that limitation on the liability set out at the beginning of Article 12.3 and 745. This is a limitation in respect of breach of contract. The limitations are set in sentence 2 and sentence 3, and then those are tempered by the exceptions in sentence 4, and that is indicated in my submission by the word "this limitation of liability." Because it's not, this doesn't refer back to PLA, the clause 7.4 of the perpetual license agreement. It doesn't need to. It takes precedence over it. In a sense, if it were inconsistent, the two actually are looking at slightly different things in a sense, because as your lordship points out, insofar as 7.4 of the PLA goes beyond contract, it's there and not inconsistent. The extent it looks at contractual obligations, and 12.3 deals with it and says, well, in addition, when you're dealing with contractual breaches, you will not have the benefit of the limitation of liability if you've been negligent.
I think what I was wondering is whether a drafter conscious of 7.4, which goes across the whole field of both contract and tort liability, and imposes a cap in relation to both, was then conscious that the main part of Article 12 is focusing on contract a cap in relation to contract might be concerned to make clear that whatever was being said about contract would not cover a tort liability, such as might be suggested if you read 7.4 with 12.3 without the care that obviously you invite us to read it.
I think in that respect, I'd end up repeating much what I said before, because these are descriptors of the breach of contract.
Yeah, sorry.
From the clause itself, and it's in that sense it is consonant with the way that 7.4 of the PLA works. Because of course 7.4 isn't saying no liability for independent causes of action in fraud or gross negligence or willful misconduct. It's saying no liability for any in a cause of action you can show if your behaviour has been such that it's fraudulent or grossly negligent or exhibits willful misconduct, you will not get the benefit of the limitation on liability. It's not doing, which I think what my Lord Sales, you were saying earlier on, which is trying to match words to different types of causes of action, because 7.4 tells you it's a limitation on all causes of action except when those behaviours are exhibited, and that in a sense mirrors 12.3. This is a limitation on liability for contractual breach, save when the behaviour in that breach exhibits fraud, negligence, gross negligence, or willful misconduct.
Yes, thank you.
Mr. Howes.
Well, the very, very last point, then I appreciate I am now over and invading on your time. Gross negligence versus negligence. The point made against by Mr. Stafford was, well, you put in negligence, you render gross negligence meaningless. This point we have dealt with directly in our written submissions, and the simple point there is, in circumstances where the parties have clearly taken the deliberate approach of inserting the word negligence next to gross negligence, it must be taken to have meant something. It must be taken to have meant to increase the scope of the exception to include normally negligent behaviour, if one likes. Certainly taking on board my Lord Legate's observation that English law doesn't recognise a particular difference as Armitage and Nurse. One reason for it to be there in these circumstances is to avoid the confusion that might have been caused by having an exception for gross negligence in a clause when the liabilities under this contract include liabilities for negligence. It avoids a scenario in which a court has to ask itself, well, there are breaches of contract here for negligence under Article 12.1, failure to exercise reasonable skill and care, but the only exception to limitation liability is for gross negligence. Now, where is the line, given that English law doesn't recognise the difference between negligence and gross negligence, where do I find the line, therefore, between a breach of the concurrent duty of care in 12.1 and negligence, and what this clause would tell me to do, should negligence not have existed there, by finding gross negligence? Okay. Making sure that the two are consonant. Those are my submissions. Thank you.
Mr. Howes, thank you very much. Thank you very much indeed. Well, the court would wish to thank counsel for their clear and succinct submissions in this very interesting case, and we'd also wish to thank those who have assisted, those who have spoken in the preparation for this appeal. The court will consider those submissions very carefully and will produce a judgment in due course. The court will now adjourn.